That's fine
Motion
with me,
first.
Judge. Will.
Okay. All right, Ms. Rademacher.
Thank you, Your Honor. Your Honor, the motion is quite simple, I believe. This court, we had a hearing on August 21 regarding child support. And the court actually encouraged the attorneys to talk over this 415 order. As I came in on this case, I was reviewing it, and it was very clear to me in black and white. The April 15th order says that a friend of the court recommendation regarding the parenting time is adopted as to all parenting time. To me, all means the entire recommendation. Then the matter was further scheduled for a review to show housing stability. So they were following up with the, after the adoption of this friend of the court recommendation. Once my client did have his home that he lives in now, that lease was provided to the court, in fact, even on that day. And we have not been able to move that forward. So I have now had to file this motion. So I'm asking the court to enforce the April 15th order. It is very clear as it's written, and we need to go into that next phase as my client has proven and they've admitted that he now has appropriate housing. Thank you.
All right, thank you, Ms. Van Dyken.
Thank you, Your Honor. The order was clear. It was the court to review the parenting time in 6 months. Not me, not Ms. Rademacher, the court. And I believe that was the discussion at the August 21 child support hearing as well. That's why the court has set the matter for an evidentiary hearing in November. With that, Your Honor, we are not against implementing the friend of the court recommendation, but there seems to be some dismissal about what that parenting time looks like. It's not week on, week off. It's simply Wednesday evenings and every.
Today's courtroom session centers on a dispute over child custody, parenting time, and enforcement of an April 15th court order. The father's attorney, Ms. Rademacher, insists the order clearly grants full parenting time and highlights that her client now has stable housing. She stresses the court must implement the order immediately. Meanwhile, Ms. Van Dyken, representing the mother, raises concerns about the father's communication with the children, emphasizing the need for the court to oversee the matter and consider potential emotional impacts before proceeding.
Every other weekend. Ms. Rademacher made that allegation in her response to my motion for custody and parenting time. We still have hesitation with the things that Mr. Griffin is saying to these minor children, which is part of my motion to change legal and physical custody and kind of withhold some of that parenting time back until he can get the ability to communicate. That was another part of the order, was that it was the ability of the parties to communicate. That's what the referee or this court was going to review at that time. With the things that I placed in my motion for legal and physical custody and parenting time modification, you can see that communication has not improved at all. So I believe this leaves it up for the court to have that evidentiary hearing to see if that appropriate reinstatement of parenting time is appropriate. Thank you.
Ms. Rademacher.
Thank you. I heard a circular argument there. The bottom line is that the 415 order needs to be implemented. If they wanted to modify that, they could have filed a different motion. Now that we've sought to enforce it, they filed this change of custody thing, which you'll rule on that next. But the bottom line is the review hearing is to review how things have been going. And so we can't, I agree with Ms.
The judge listens carefully, noting the April 15th order is clear and enforceable. He points out that any modifications must come through a separate motion, not unilateral attorney decisions. He grants the father's motion to enforce parenting time but reminds the attorneys that an evidentiary hearing is imminent, where full review of custody and parenting issues will occur. Both parties are instructed to follow the order precisely while the court prepares for further evaluation, ensuring the children's best interests remain the top priority.
Van Dyken, that the attorneys can't unilaterally make those decisions. The court can. That's what the review hearing's for. We need to implement the order as written. It's very clear. Thank you.
All right, thank you. I will grant the motion. However, we are looking at an evidentiary hearing coming up very soon. So at which point the court will review all of it. But I will grant the motion.
Thank you, Your Honor.
Moving on to the motion to modify custody.
Thank you, Your Honor. I believe that we've reached the threshold to have the court take a look at the best interest factors of these children. Again, with the comments that the father is making to these children clearly affects the children and the best interest, their emotional well-being as well. So it does affect not only that best interest factor, but many others. As for the change of physical custody, Your Honor, while I understand that physical custody is not a statutory mandate, we've always assumed that when the parties have joint physical custody, people think that they have 50-50. They do not. As for the parenting time, we still have the ongoing same concerns about Mr. Griffin's involvement involving the children in inappropriate comments, inappropriate communication. He's inserting himself into educational endeavors that are educational endeavors and confronting my client at the school.
Attention then turns to the mother's motion to modify custody. Ms. Van Dyken argues that the father's statements to the children affect their emotional well-being, potentially compromising their best interests. She cites inappropriate involvement in school matters and hostile communications between the parties. Her motion requests a thorough review of custody, legal and physical, at the upcoming evidentiary hearing. The attorney emphasizes that the court must carefully assess the situation, considering the children's emotional stability, academic involvement, and overall welfare before any final decisions are made regarding parenting time adjustments.
Where teachers and other adults had to intervene from him approaching her, and they were the ones who asked her that she should call the police, because the communication and the involvement between the two parties is hostile at best. We believe that we've reached the threshold, and this court can then look at the same physical, legal, and parenting time when it does its review in the soonest evidentiary hearing in November. Thank you.
Thank you. Are the parties using Our Family Wizard or AppClose or any of those kinds of apps?
Our Family Wizard, yes.
Yes.
I thought so. Okay. All right. Thank you. Ms. Rademacher.
Thank you. Your Honor, I disagree entirely. The parties are using Our Family Wizard. We don't have any attachments as an offer of proof. The parties have communicated regarding, I mentioned their son, LEG, who went through a whole autism assessment. The parties did agree on getting the assessment. They've agreed to the medication. They've attended many IEPs with him. And also CEG has had a little bit of school involvement in IEP type meetings. So there's nothing that has been alleged that impacts a timely decision or parenting of these children other than these parties.
Ms. Rademacher firmly disagrees, highlighting that both parties use the Our Family Wizard app to communicate, and that no proof supports allegations against her client. She asserts the children remain stable in school, and the parenting concerns raised are largely disputes between the parents themselves, not evidence of harm. She proposes a practical solution for exchanges: St. Mary's Hospital parking lot, with each parent remaining in their vehicle while the children move between them. She emphasizes the importance of clarity and safety in these exchanges, while maintaining the children's routine.
Don't like each other, quite frankly, and that is not a basis for change of custody. They mentioned late exchanges. That is not a threshold. In fact, there's no offer of proof at all. My client indicates he's a very timely person. He does not even understand that allegation. What they've indicated is there's a hostile demeanor by my client. Their pickup and drop-offs are at Safe Connections. When I was asking, and I mentioned that when I came in on this case, they are at Safe Connections already. When I was talking to them about this allegation, they don't even do the normal exchange that I would have assumed Safe Connections meant, and that's where one party drops off, the kids go in the building, and so on. No one informed these people that that's the process. They were just literally meeting in the parking lot at Safe Connections. I wish they would have known better. Now,
if I could just interject, unfortunately, Safe Connections is no longer, they lost their funding. So there's going to have to be something else figured out on that. So I just wanted to interject that.
Yep, I mentioned that in my response. So what we looked at is where Safe Connections were. We think St. Mary's, because it's 24/7, has security and so forth. And we think the parties can just stay in their car. They don't need to be outside of their car, which unfortunately Safe Connections did. But the problem with the children,
The judge addresses logistical challenges, acknowledging the need for specificity in choosing an exchange location. Parking availability and surveillance cameras are key considerations to ensure safety and consistency. Both attorneys agree to inspect the site and select a definitive spot for exchanges, with a backup plan nearby, including the Grand Rapids Police Department if needed. These measures aim to reduce stress on the children and ensure smooth, conflict-free transitions between households. The court stresses that parenting logistics must support the children, not add tension or uncertainty to their routine.
I think when I'm reading this motion is they clearly are becoming reporters for mother. That to me is a red flag that the mother is involving them in regard to this matter. What we do is the remedy is we modify the exchanges. We don't modify custody. We need to just clean that up a little bit better. So I do ask the court to allow that St. Mary's exchange. The parent stays in the car with the kids, the other parent pulls up 4 spaces away. The kids are old enough that they can hop into the other one. This alleged incidents at school, my client again was never contacted by teachers, never contacted by police, never contacted by principals. He reached out and we attached that as an exhibit. Was there ever incident? The exhibit, the principal confirmed she looked no incidences in regard to any problems. So again, the offer of proof is insufficient, and certainly my client would have heard something even from the plaintiff. You would think she would have said, "Hey, what happened today?" or "Your behavior was inappropriate," even on our family wizard. They alleged the drinking as a threshold argument. No evidence of that other than children reporting.
Discussion shifts back to the evidentiary hearing, which will address custody modification. The judge explains that referee Kessler, familiar with the case, will preside over this hearing and issue a ruling on the motion. Both attorneys acknowledge the schedule, understanding that the hearing will cover parenting time, communication issues, and any adjustments necessary to safeguard the children's welfare. The court emphasizes that it must review all relevant evidence and testimony before deciding any changes to legal or physical custody, ensuring decisions reflect the best interests of the children involved.
We attached his wife little statement as to their behavior, what they do as a family. There's no arguments or offer of proofs in regard to any parenting that's affected the children. They're stable in school, and the only thing that they seriously desire is to spend the time back with dad that they aren't allowed. But thank you for at least granting the first part of that motion. So the bottom line is that Marie Kessler back in April heard many of these same or similar arguments. She granted a review in regard to what she deemed were 2 issues between the parties: their communication and the housing stability. That's all. Nothing else has changed. And we have a hearing date for those 2 issues. So again, I believe that this motion fails in its offer of proof, and even the allegations themselves. Remedies are more addressed to communication and exchange versus a change of custody. Thank you.
Right. Ms. Van Dyken, any response to the change of location for exchange?
Your Honor, I'm just saying a parking lot at St. Mary's is insufficient. I mean, there is a front parking lot by the hospital. There's one across the street. There's a parking structure. There's one in the back lot. I mean, I think we need more specificity with that. Quite frankly, just saying a parking lot is not appropriate. I'm not sure that there are cameras in all of the parking lots like the one across the street. I think it would have to be in the main parking lot in front of the hospital.
I see Ms. Rodemaker nodding her head. So that sounds like...
I'm not sure there's always going to be access to that, because I've been to the hospital where that parking lot is full and you have to go park in the ramp. So I'm just saying there's going to be
issues. Ms. Rodemaker, any thoughts on that? That's a fair point.
So if the exchange is in the evening on Sundays, he would pick up from school on Fridays, so we're good there, and he picks up Wednesdays. And I think I don't recall what the Wednesday parenting time is if
Evening.
it's an overnight or just an evening. Let me
It's
see
an
here.
evening.
Weekdays, Wednesday until 7:30. So we have Wednesday night exchanges and holiday exchanges and Sundays at 4:30. So the only thing I can suggest is I haven't scoped out that main parking lot lately, but perhaps Ms. Van Dyken and I can look at that parking lot and pick a corner that they can exchange, or maybe even up near the front if there's cameras. I don't know how to describe that, but I'm pretty sure we could figure out where in the parking lot.
Okay, and you probably would need it. You would need a backup.
Yeah.
Is what I'm hearing.
Okay.
A very
And we're not
clear
that-
plan.
We're not that far from the Grand Rapids Police Department on Monroe Center Drive. Perhaps that could be the backup.
Okay.
All right. So what I'm going to do on the motion to modify custody is I am going to set that for the evidentiary hearing. I'm going to adjourn it because I have not been the judicial officer dealing with this case, and I think referee Kessler's probably in a better position, even though I've read everything, to rule on that. And I'm not. Frankly, it's not clear to me either way, so I'm just going to defer and set it at the same time as the evidentiary hearing for her to rule on the motion.
Thank you, Your Honor.
Thank you, Your Honor. So to make it clear, our evidentiary hearing will proceed as to parenting time, and then Ms. Kessler would rule on the motion.
That's correct.
Okay. And then Ms. Van Dyken and I will confirm the location in the St. Mary's parking lot and back up as
And a
chair.
backup. Yep. All right.
Can I
Anything
ask
else?
one more question?
Sure.
Do we know whose weekend this weekend would be? And my client's indicating it's your client, so we'll start with his next weekend.
Next Wednesday.
Well, Wednesday, yes, I agree.
Okay.
Yeah.
All right.
and his weekend next. All right. Thank you so
Thank
much.
you, Your Honor.
And before we leave, I just want to admonish both parties: do not talk about what's going on here with your kids. They feel, regardless, they feel that they're half and half, each of you, and so any disparaging remarks, any negative comments about the other parent, they're internalizing, whether you think they are or not. It's just really damaging to them. So please don't do it. If you love your kids, don't. Okay. All right. We're adjourned. Thank you.
Thank you, Your Honor.
Okay, thank you.